cognizance cognizance of offense and commencement of the judicial proceeding. Cognizance of offense and commencement of the judicial proceeding. Com- Cognizance of offense and commencement of the judicial proceeding. Cognizance offense हो गया, cognizance offense. Cognizance offense हो गया, cognizance offense. Cognizance by whom the following class of the magistrate court can take cognizance of offense हो गया. By magistrate of the first class may take cognizance of the any offense. Section 190 B. Any magistrate of the second class, if specially so empowered by the chief judicial magistrate. Chief judicial magistrate may take cognizance of the such offence or within the competence inquiry into the trying this, except as otherwise expressly provided by the code or by any other laws. A session court is not to be take cognizance of any offence such as court of the original jurisdiction unless the case has been committed to the by its magistrate. It is measure cognizance when taken. Cognizance when taken, a magistrate as mentioned above may take cognizance of offence. Cognizance of offence हो गया, cognizance upon receiving a complaint of the fact with constitute such offence. B. Upon a police report of the such fact. Police report on the such fact हो गया, police report on the such fact. Upon information received from any person other than a police officer or upon this on knowledge that such offence has been committed. Section 190 हो गया, Section 190 हो गया, Section 190 हो गया, Section 190 धर्मपाल वर्सेस स्टेट ऑफ हरियाणा. 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 ट्रांसफर ऑफ केस अंडर क्लोज 3 above and section 190 clause 1 subclause C. The magistrate may take cognizance of an offence upon this on knowledge or information, but in such a case section 191 required that section Gopal Sindhi versus State of Assam. With the State of Assam हो गया, State of Assam हो गया, State of offence. Time limitation. Magistrate can take cognizance of an offence only within the time limit prescribed by the law for this purpose. बस law this purpose हो गया. Restrain on taking cognizance. Any person may set the criminal law in motion by filling in complaint even thought he is not personally affected. Whoever section 195 impose limitation on the wide power of the magistrate to take cognizance of an offence under section 190. These restraints are based on the sound policy consideration. Full stop. The limitation imposed by the section 195 on the power to take cognizance of offence shall be presently considered. Limitation on the power to take cognizance of an offence. Section 195 are exception to the general rule containing in section 190 regarding taking cognizance of an offence. Full stop. The analysis of the section 195 will bring out the following points. Prosecution for contempt of the lawful authority of public servant. No court shall take cognizance of any offence punishable under the section 172 to 188 Penal Code 1860 of an abetment of an attempt to commit such offence or any criminal conspiracy to commit such offence. Commit in such offence हो गया. Prosecution for prosecution for offense against public justice and for the offense related to the document given in evidence. No court shall take cognizance. No court shall take cognizance for any offense punishable under any of the following section of the IPC, namely section 193 to 196, 199, 200, 199 and 200, 199 and 200, 199 and 200, 199 and 200, 199. The purpose of the section 195, clause 1 subclause B is to be bar private prosecution where the course of the justice is thought to be pre-converted, leaving it to be the court itself to uphold to its dignity and prestige. Full stop. In case of wherein the complaint made by a party against another was proceeded by the choice officer and came to be proved false. Came to be proved false. Okay, came to be proved false. Came to be proved false. Okay, came to be proved false. Prosecution for offense against the state. No court shall take in cognizance of any offense punishable under the chapter number 9, chapter number 6 or section 153A, 153B, 195A, section 505 IPC, section 505 IPC. Okay, section prosecution for the offense of the criminal conspiracy. Prosecution for the offense of the criminal conspiracy. No court shall take cognizance of the offense of the criminal conspiracy punishable under section 120B IPC other than in criminal conspiracy to commit an offense punishable with death, punishable with death, imprisonment for life and rigorous imprisonment for a term of the 2 year or upward unless the state government or district magistrate has consent in writing to the initiation of the proceeding via prosecution of the judge and public servant. Prosecution and judge of the public servant. Prosecution of the judge and public servant हो गया. Prosecution of the judge and public servant हो गया. Prosecution of the judge and public servant हो गया. A question rose to be whether an officer of the public sector officer. Prosecution of the member of the armed force. Prosecution of the member of the armed force हो गया. Prosecution for the offense against marriage. Prosecution for offense. Prosecution for offense against the marriage. No court shall take in cognizance of any offense punishable under the section 20 of the IPC, except upon a complaint by the some person irrigate by the following the offense. The above rule also apply to respect of the amendment for attempt to committed any of the offense mentioned in the section. Under section 156 clause 3 हो गया. Pre-cognizance stage हो गया. Pre-cognizance scrutiny of the complaint. Pre-cognizance stage we have already seen the definition and meaning of the term complaint. Full stop. A complaint can be oral or it can be writing. It can be examination of the complaint. If the magistrate apply this mind to the offense complaint with a view to take subsequent step. That means if the magistrate take cognizance of receiving the complaint, the first step it required to take into examining the complaint on oath under section 200. Under section 200, provide that magistrate taking cognizance of the offense of the complaint shall examine upon the oath of the complaint and the witness present. Witness present. विटनेस प्रेजेंट हो गया, इंक्वायरी ऑफ इन्वेस्टिगेशन फॉर फर्दर सिक्योरिटी ऑफ द कंप्लेंट, सिक्योरिटी ऑफ द कंप्लेंट हो गया, सिक्योरिटी ऑफ द कंप्लेंट, इट हैज बीन clarified by the Supreme Court in Vijay Panuka versus Nizma Mumtaz that expressly in section 202I prima facie marks the inquiry or investigation as the case may be by the magistrate full stop. The court also note that the amounted to section is 202I 202I effect in 205 signified that the legislature thought it initially by spelled out to avoid false complaint that we write in filed against person residing after that placing dismissal of the complaint dismissal of the complaint okay, dismissal of the complaint okay, dismiss issue of process okay, issue of process if the magistrate taking cognizance of the offense consider that there is sufficient ground for proceeding he shall issue process against the accused person in the following manner briefly speaking, while in a summon case in magistrate is required to issue a summon, in a warrant case has been discretion to issue neither a warrant or summon full stop. Even a summon case may be issue in a warrant after recording this special reason for doing so under section 77 full stop. These special summon in case of petty offense section 206 has been enacted to avoid unnecessary innocence to person accused of the petty offense and also to reduce to some extent cognizance in magistrate court. In magistrate court, full stop, the session provide abrogate procedure in the disposal of the petty case in which the accused person may be inclined to plead guilty. Full stop. For this purpose, the magistrate has been empowered to issue a special summon to the accused person in analysis of the section with bring out the following point. Okay, bring supply to the accused person copy of the statement, document, and police report. In any case, constitute on a police report. The magistrate is required by section 207 to furnish to the accused without delay and free of the cost the copy of the each of the following: A. The police report. B. The first information report FIR. C. The statement record under section 161 clause 3 of the all person who the prosecution purpose to examining has it witness. D. The confession and statement if any recorded under section 164. D. Any other document or relevant extract thereof the toward to magistrate within the police report under section 173 clause 5, wherever the magistrate satisfy that any such document okay, commitment of the case to the session court. Certain offences are exclusive trial by the session court according to the section 26. Read with the first schedule. Such court cannot, whoever, directly take cognizance of this offense cognizance of this offense हो गया, cognizance of this offense, it can be deal, it can